So please get ready your Legal Profession Act and also LPPER review in order to discuss what we call the paper better. Okay, just a little bit of disclaimers here. I'm just a very junior person in law, and of course, I do not guarantee or assure you the quality of this teaching. This is on pro bono basis, and you have to do your own reference or cross check lah with regards to the answer. Okay, and very important for you to know that by now you should know, PP very special paper. You have to do your question faster than other CLP subjects. Okay, you are required to finish 5 questions within 3 hours. So roughly you can allocate about 30 to 40 minutes for each question. Do not drag too long. Okay, straight to the point, then go to other question. Time management is very, very important. Okay, we'll go to question number one because we are going to discuss 6 questions altogether today. So please bear with me lah. I'll go a little bit fast today. First question, an advocate and solicitors owes a duty to his client, to the court, and to the legal profession. This is by Muhammad Zawawi Saleh, as his lordship then was in Lai Chi Meng against Ong Beng Lai. Okay, so what did the Zawawi judge say is that ultimately, as is often the case, it is apt to heed the words of Sir Owen Dixon in a setting the bar, unless high standards of conduct are maintained by those pursue a profession requiring great skill begotten of special knowledge, the trust and confidence of very community that is to be served is lost, and thus the function itself of the profession is frustrated. So first statement is there. And second statement, it has been repeatedly stressed that the practice of law is not a business. It is a profession in which the duty to public service, not money, is the prime consideration. Lawyering is not meant to be money-making venture which necessarily reaps profits. Making of livelihood should be secondary consideration of lawyer who must be subordinate their interests. So in Bar Council of Maharashtra against MV Dobokar, etc., so Indian case, it was stated that members of the bar are not a guild of candle makers or butchers association. They are a class separate. So, in what way do the rules of professional practice and ethic made by the Bar Council pursuant to Section 77 of LPA ensure that each of the above duties are fulfilled? So your answer should relate especially to the legal profession, practice and etiquette rules 1978 and also solicitors account rules 1990. To approach this question better, if you have not come across this judgment before, the advice is don't answer. Remember, I repeat one more time, do not answer if you are not aware with this case at all. Okay, because your answer most of the time is just based on your opinion and it will be wrong. Okay, so you start your answer with section 77, whereby 77 of this Legal Profession Act actually enables Bar Council with AG's approval. Okay, maybe I should highlight. Where is it? Okay. With AG approval, they can make rules, regarding to legal practice. So Bar Council is given the power to make laws. So this one is just like local council, like Bandar Raya, Johor Bahru, something like that. Okay. And subsequently, um, this regulatory framework is actually for what? Why Bar Council is able to make rules? Because this is the intention of the Parliament for legal practice to be self-regulated by our own members. So among the rules that you are being asked to discuss would be the LPPER as well as the SAR, which are very important lah. Okay, these two, because misconduct usually come from these two, infringement of the rules. Okay, so in light of this case, Lai Chi Meng here, Lord Zawawi specifically mentioned, that's why you cannot glantong everything, You must be familiarized with the case. So he specifically mentioned two rules out of LPPER, namely Rule 3 and Rule 5. So Rule 3 is what? Rule 3 is actually is about the embarrassment, the conflict of interest, something like that. Okay. If let's say, for example, a lawyer acted for a party, for his or her client, in a way that could have caused embarrassment to himself, he should avoid. Okay, so what does it mean by embarrassment? It's actually defined under your Rule 3B of LPPER. So whereby number one is that the lawyer has got confidential information, okay, regarding to the opponent, especially opponent parties of the suit. And second thing, personal relationship between lawyer as well as the party. The case here must be apa nama? You must familiarize or a witness in the proceeding, So that means as a lawyer that handle the case, you must be absolutely neutral. No personal relationship or nexus with any parties or witness in the proceeding. This will enable you to act freely, fearlessly, maintain your professional integrity. So this is pursuant to your Rule 3. Rule 5 is about professional independence and avoid conflict of interest. Okay, so again, it is divided into A and B, this Rule 5. Okay, so you must avoid anything that could have caused conflict of interest. You cannot be prejudicial or be influenced by the suit itself. So Rule B states the condition whereby there is conflict of interest. Okay, that is to prevent, okay, uh, lawyers who have previously advised, drawn pleadings, or acted for a party in legal proceeding from acting for opposite party in the same manner. Take for example, A sue B. Okay, A come and approach. Okay, B come and approach you, and have already discussed the case, and then you get advice so and so, but subsequently B did not engage you, did not pay you. But now A, who is the plaintiff in this suit, approach you and pay you generously. Now you know about the weakness of this B. So can you act for A? The answer is no, because you have already previously discussed the case with the uh, B, the defendant of this suit. Okay, this one, if you watch the Hong Kong movie, the 毒舌大状, actually is there, Okay, this is conflict of interest, one of the strategy that play by the parties lah. Okay, so second, requires written consent. Take for example, you have acted so lah, but then because no choice, you still have to earn your living. So you must acquire written consent so that the other party will not be prejudiced. Okay, so this is about the first statement by Lord Zawawi. So second statement is coming from members of the bar are not guilty of of Candle Makers or Butchers Association. So what is he trying to say here? Okay, that means to say the lawyer is actually different class of people, They are trying to uphold the noble profession of as a lawyer here. Okay, so your answer again must come back to LPPER as well as SAR. So come back, same answer, rule 5, discuss above, okay, the conflict of interest. And additionally, you can put in rule 16, whereby advocate and solicitor must uphold the interest of justice and also the dignity of the profession. And this one, rule 35. That means to say you cannot abuse the confidence reposed in him by a client. Okay, we cannot abuse, let's say, for example, a lot of cases, the take for example, you act for a developer. He's going to develop a big project of this particular land. And then you go and abuse this sort of confidential and also confidence, and then go and before him, you bought over some of the land like that, and then sell him back. This one cannot. Okay. And what are the SAR ruling that support the statement is that Rule 3 of your SAR 1990. This one you must be familiar, The client accounting, a lot of disciplinary action is actually founded on this SAR 1990. A lot of lawyers got struck off the road, okay, because of infringement of SAR. Okay, you must pay money into client's account. This one, you hold it as stakeholder, very important. So rule 6, no other money to be paid into client account. You cannot mix the fund, you cannot use it for your salary lah. Let's say, for example, you are sick, you use the client's account for your medical bills, all that. Cannot, okay? And then you must keep account book and surrender for evaluation of accountant at every year end. Okay, this is very important, especially if you are the equity partner of a law firm. Okay, and you cannot simply draw the money from client account other than for the purpose as instructed by client. Okay, you cannot deduct the money, or I take for example the client owe you 30,000 legal fee. So you take the money you hold for trust and deduct the legal fee. That one also is not allowed. Okay. So by enforcing all this, okay, so-called the integrity and trustworthiness of legal profession can be hold. Okay. So this is what they are trying to say. Okay. Like I say again, if you are not too sure about what they ask, don't try your luck. Okay. So second question, Kanda, an advocate and solicitor, and also a partner in Mrs. Kanda, Tinder, and Co., was approached by Andy. So you see, okay, Andy is being sued by one of his creditor, Franco, who is a distant cousin. Okay, now you start to see the relationship, the personal relationship is there. Okay, so Kanda know that Franco, a hardware operator, dabbles in counterfeit products. A few years ago, Kanda's firm had represented Franco in a suit by another customer and had learned about Franco's trade secrets. Okay, so you see, and other sensitive information. Given that Kanda was the head of the dispute resolution team in the firm, he was indirectly acquainted by the facts and the documents. So, highlight a bit here. Now is the case Franco suing Andy, and Andy is your client. Okay, is your client. So what subsequently the fact trying to suggest is Andy's main aim is to buy himself some time to dispose his properties so that any judgment, if obtained, will be incapable of being executed. Kanda's mission, if he chose to accept it, is to delay the process and discharge him at the appropriate time. So Franco, on the other hand, learned that Andy wants to retain Kanda firm because they are, you know, relative, isn't it? He then approached Kanda and informed him that if Kanda can conduct the case, which can result in a judgment being entered in Franco's favor, Kanda will be remunerated handsomely with nothing less than 20% of the judgment sum. So advise Kanda on the ethical issues in this case. So you can see the ethical issues. What are the ethical issues? First is about conflict of interest. So rule 3, as I have told you earlier, you cannot accept something that can cause embarrassment to you. And 3B, rule 1, confidential information because of your standing as head of dispute resolution, and also you have well defendant previously, you cannot take this case. Okay, and 3B, you have 3B sub rule Roman 2, you have personal relationship with Franco, okay, cousin of Kandas. By right, you should also avoid to take this case. And Rule 5, Sub-Rule A, accepting the brief which will compromise professional independence and administration of justice. Rule 5B, Sub-Rule Roman 1, Kanda's firm previously represented Franco, so he should not act, okay, he should not act unless the other party return consent. Okay, like that. So this is conflict of interest. And secondly, you must also talk about general rules. Okay, Rule 9, because the mark is there, 10 marks, isn't it? So elaborate and extend your answer to cover more rules if you can make out. Rule 9A, Kanda must defend Andy fairly and honorably. So here you can see the second paragraph, isn't it? Andy's actually is trying to evade his legal obligations by delay. Okay, so that he does not need to pay for the judgment sum. He know he's going to lose that. That's why he want to sell his properties first. Okay, and rule 16. This is very general. Uphold justice of the profession. You cannot compromise it by helping Andy in evading legal obligation. Okay, so rule 35. That means you cannot abuse the confidence that put forward by your previous client. The facts suggest that Franco was actually Kanda's customer, assisting customer. So you cannot abuse this sort of confidence or trust relationship. Okay, even the employment is terminated. Okay, very important, And last but not least, you must also identify the separation, the division of the commission. 20% out of the judgment sum is a form of outing because you share profit with Franco, who is an unqualified person. Okay, very important. So you must highlight all these issues in your answer. Okay, put in the rules, be straightforward, and then put in a conclusion. So at the end of the day, you just conclude with one. I mean, you should not accept this case at all. Okay, this is going to form a good advice for Kanda. Cannot accept at all. B, although there was no express retainer, a solicitor-client relationship may be implied from the conduct of the parties and the circumstances of the case. So based on the statement above, give three examples where the courts have held that there was an implied retainer. Okay, first of all, you must know what does it mean by retainer. Okay, LPA itself does not actually define or interpret the meaning of retainer, but retainer itself is actually refer to the contract, between solicitor and client. Usually in a matter of practice, it is an agreement for engagement. Take for example, a patient approached me, okay, to sue for medical legal case. We will highlight what is the scope of our job. For example, we'll file discovery order, and then we will file rid of someone. We'll attend how many sessions of case management for you. Oh, so we list now and itemize into a so-called a formal agreement, a written one. The other party should sign and agree, as well as this sort of agreement will contain about the cost agreed. Okay, so this is the starting of our relationship, because most of the time you have to make it clear lah. Otherwise, you will keep on collecting the money from the client. The client will not be happy. So you make it black and white. It will be more transparent to outline what are the duties of the client to provide us the documentary evidence, and what are the duties of us as a lawyer to him or her. Take for example, for my situation, I will have to approach some medical expert and then help out with the cases, something like that. Okay, so the retainer should state the duties of both client and lawyer when established, and as to the cost also to when handle the client's case. So a retainer can be expressed or implied. Express retainer is usually what we use often. Why express retainer is very important is that whenever you have dispute with your client, the client can discharge you, isn't it? So what if you have done halfway? For example, you have filed the read, you have the case is about to go for trial. Suddenly, the client feel that, okay, I don't need you anymore. I discharge you. So these are among the tricks played by smart client. So what is the fee that you ought to collect? You must have a written agreement, to outline all this. Otherwise, people can complain in bar council that you are charging them too high, or you have not done adequately for them. So usually retainer agreement in as a matter of practice usually is expressed black and white. As for imply is very broad. Okay, implied retainer actually arise from the conduct the parties, as well as it involves action and communications between solicitor and client. In such a way, whenever an implied retainer had been actually formed, then automatically a lawyer will owe a duty of care towards his or her customer. Very important. If let's say, for example, implied retainer is there, whether you like it or not, there is a relationship already. If there is a relationship, then the client can sue you for negligence one. So this is why implied retainer is also equally important. Okay. To answer this question, the main reference you can find from the federal court decision in Gubachan Singh against Velasamy Penusamy. Okay, so whereby the federal court say that whether the existence of and scope of duties in a solicitor-client relationship is determined only by reference to retainer. That's why I said to you, okay, when the nexus, because normally lawyer do not owe a duty of care towards anybody, isn't it? The remoteness test is there. Okay, it will be too far and distant to pass this sort of heavy responsibility on us. But then, this case, federal court actually brought two cases examples of implied retainer. They used actually more than that. I just quote three cases from this federal court decision, the Gubacharan Singh case. First one is Yong and Co. against V Hood Tech Development Corporation. In this case, the judge found that a retainer existed by implication based on documentary evidence and subsequent conduct. So documentary evidence here is maybe there is some exchange of correspondence between solicitor as well as the client, and also what the lawyer did to show the cost of dealings between them. Okay. And second case is Lee Henry Bruce Lee against Wong Tan and Molly Lim. Okay. Whereby the court held in this case, okay, um, they said the absence of express retainer did not negate the existence of a solicitor-client relationship if the conduct and interaction of the parties indicate such a relationship. Okay, so you must be aware of that. Okay. And Floodgate LLP Limited Liability Partnership against Harrison. So this case, actually, the court held that the giving of instruction by a client to a solicitor actually already form the retainer relationship. Okay, very important. So these three cases is the examples to support your answers in imply retainer. Okay. And third question, we go to Atul, an advocate and solicitor, has been in practice since 1998, all the while in a partnership with Balan. A complaint was lodged by one Atul's client, Minggu, that Atul had failed to disburse Minggu the balance of the sale price of 880,000 ringgit in a sales and purchase transaction where Atul acted for Minggu, the vendor. Okay. Atul claimed that the money was misappropriated by Balan, who had control over his check, which had been pre-signed by Atul. So a disciplinary committee was actually formed to inquire into the complaints against Atul by Minggu. Advise Atul on the following. A. Whether the complaint must be made within specific time, as he believes 3 years had lapsed from the date of the alleged misconduct. Okay, so the question said that actually the money was swindled away by Balan, the partner, lah. And Atu asked you if 3 years had been over, 3 years the course of action accrue, whether this action is not founded or the lapse of time had caused the action to be barred. Okay, is that so? So you must refer to specific provision of the laws whereby section 99(3)(a) of LPA. Okay, the proper limitation period is 6 years. So this is your answer number one, as well as you must refer to your sections 6 of legal profession disciplinary proceedings rule 2017. Okay, so this one all say that 6 years is the limitation period. So therefore, this what we call to advise Atu, the complaint against him is not lapse. It's just 3 years as compared to 6 years. Okay, very important. So second question is that whether Atu may apply for a judicial review against a ruling of the disciplinary committee in the course of hearing the complaint. Okay, in answering this question, you can look at second question also, whether Atu can file a judicial review against the final decision of the disciplinary committee. Okay, you must refer to the amendment, the this one. Okay, you can find it in LexisNexis. This is the Legal Profession Amendment Bill 2012. Why I want you to refer to this amendment bill is that it describes the answer for this, the rationale behind the amendment and the introduction of this section 103 EA and also section 103 EB in your Legal Profession Act 1976, and also the deletion of some of the proviso inside your section 103E. Okay, it is very important. Sorry. I think there's something wrong with yeah. Is it better now?
Yes, yes.
Okay, we continue. Okay, I just repeat myself. This question is entirely based on the resource, Legal Profession Amendment Bill 2012, where you can find from LexisNexis. This is talking about the amendment and also deletion of provision inside your section 103E and also the introduction of section 103 EA and EB in your Legal Profession Act. So this amendment actually, they want to prevent, okay, they want to provide remedies for the advocate and solicitor who face disciplinary action and then subsequently they suffer from injustice due to the disciplinary hearing. Very important for us to know, whenever you have a disciplinary action, your life and fate is entirely based on the DC. Actually, DC, disciplinary committee, will comprise of three members, two senior lawyers plus one lay person. Usually, those lay person are coming from professional individual. For example, a teacher, engineer, a director of some famous company. These three people will form DC and then subsequently they will decide after the hearing whether you are guilty or not. I put it very simple. And then they will give their recommendation to disciplinary board. After that, disciplinary board, whereby that is called your ASDP, they will have a meeting and they will either accept the decision of DC and punish you accordingly, or they can reverse the order of DC and put in their new punishment against you if you have any DB action. Okay. So whenever you have this sort of proceeding, it is of quasi punishment in nature. That means to say the disciplinary board can struck off your role, suspend you, or give reprimand, warning to you, or even order monetary restitution against you. So, in this manner, the natural justice, we have two principles which are very important: the right to be heard, and also there must not be any bias. That one is very important. So, if let's say, for example, you do not have any remedies for judicial review. Judicial review in this meaning mean semakan kehakiman. If you do not ask the court to step in and observe whether natural justice principles is being upheld by disciplinary committee, then the only way left for the advocate and solicitor who got punishment, take for example, struck off the rule, will be only by way of appeal, appeal to High Court. But at the same time, you must understand, appeal is a paper process, it's just a paper submission. This is not a form of retrial or rehearing. So during this sort of appellate process, number one principle is that the High Court will be very slow in interfering the decision of disciplinary board. So basically, you appeal also no much use, isn't it? In the case that you argue there are some infringement of natural justice. But at the same time, you must try to understand, there are some advocate and solicitor who caught by those disciplinary action, they will try to delay the disciplinary hearing by filing judicial review. So these are the delicate balance that you must try to understand. So answering this question, okay, against a ruling of disciplinary committee in the course of hearing, the answer is no. You cannot apply for judicial review during the course of hearing, because this is not a final decision. Okay, not a final decision. Okay, so the answer is this one, no judicial review during inquiry. And you can find the answer in section 103 EA subrule 6 of your LPA. If let's say, for example, disciplinary board had made final order or decision, then you can seek for review. Okay. So against the final decision of disciplinary committee, okay, this one is quite tricky. Because at the end of the day, and this one is just my personal input, I suspect that the examiner might have wrongly put, disciplinary committee does not make the final decision. It is the ASDB, the disciplinary board, that will give the final decision based on the rules. Okay. I don't know why they put committee lah. Okay. So I will frame my answer as it is the final decision by disciplinary committee board. Otherwise, your answer will be same with the above. You get what I'm saying? Uh, y- anyone understand what I'm trying to say? DC, three people recommend what is their punishment, but this one is not the final decision. The recommendation go to DB. DB meeting. DB members a lot, consists of chairman, usually those retired federal court judge or sort of appeal judge, and also very senior members of the bar, 20 over years experience, and also the bar council president. So DB will give punishment like that. Okay. So in order for us to discuss this question, I will personally think that actually this one is against the final decision of disciplinary board, not DB board. Okay. I put it this way. So the amendment to section 103E subrule 2 remove previously memang cannot. Okay. Previously memang you cannot have any judicial review of the disciplinary board's decision. But after the so-called 2012 amendment, the said proviso was being removed. So the parties, the lawyers especially, who suffered unfairness can do two things at the end of the disciplinary board's final decision, that is to appeal to the High Court. But like I say, if you appeal, appellate process is just paper submission, and the High Court will be very slow in interfering the decisions of TB. You are left in a very devastated manner, whereby if you feel that the natural justice is not being observed during that particular hearing, take for example, you are not being called to enter into your defense, you are not being granted with the rights to be heard, this sort of thing you can seek for judicial review over the final decision or orders by disciplinary board. Okay. So, like I say, ATO will retain the right to appeal against the final orders or decision made under subsection 94 of 94 subrule 4 of LPA. And also, second way is to apply for judicial review. Okay. So the said right is actually given in your section 103EA subrule A. Okay. So in order for you to advise ATO, okay, so ATO can actually apply judicial review within 30 days against the final decision of the disciplinary board. So the procedural rule for judicial review is according to Order 53, Rules of Court 2012. Okay. And the removal is very important for you to highlight. The removal of subsection 103E subrule 2 enables ATO to file judicial review against DB. Okay, so thereby providing ATO with another legal avenue to challenge the outcome. Provided judicial review is not something that you can simply file. It has got a very high threshold. In fact, it is two stages thing. First is the lift stage. You must get the permission from High Court judge for you to go through the judicial review process. Lift stage, huh? Okay. Most of the time, the lift stage will fail because there's no grounds. The grounds for you to file judicial review should be based on procedural improprieties. That means the what we call the hearing was not being conducted nicely or according to the procedure set out. There is illegality element, irrationality of the decision made, or disproportionality, okay, or what we call as Wednesbury unreasonableness. This one is very complicated area of law. Judicial review is not something that you can file like a writ of summon. Okay, the second stage, if you pass the leave stage, it will go to substantive stage. Substantive stage, then only you talk about the merits of the case. So not easy, not easy. Okay, but in submission, if it is the final decision or final order of disciplinary board, ATO can apply for judicial review. Okay, this is the answer. And C, whether ATO may seek costs from Mingu as he believes the complaint is frivolous. Take for example, if a nasty client go and complain and waste your time, can you ask the cost back from him? Okay, the answer is yes. Section 103 EB allows an advocate and solicitor to seek for cause if the disciplinary board dismiss a complaint and okay, it's not just dismiss, then you are allowed to seek for cause because complaint is actually a mechanism to redress the problem. You must bear in mind, not everybody complain subsequently you are freed, you are not being found liable or guilty, then you can counterclaim the other complainant. Not like that. The disciplinary board must record it as frivolous or vexatious. That means intentionally or maliciously done, okay, against the advocate and solicitor. Uh, so section 103 EB subrule 2, how Atu can do is he should apply by OS plus affidavit for order of cost. Okay, and the court will determine the quantum of cost. So section 103 EB subrule 3, the court can actually order for any cost that deemed to be reasonable. So the conclusion is yes, Atu can seek cost from Minggu if two conditions: the complaint had been dismissed, plus the DB records it as frivolous or vexatious. Okay, and Atu must file or as, okay, and then the court can order so. Understand, eh? Okay. So question D, the standard of proof that is applicable at the disciplinary committee. Okay, in UK, UK, it is of balance of probabilities for any the GMC, what we call that one, GMC, General Medical Council, or their bar council, is all balance of probabilities. But in Malaysia, we are slightly luckier. We have beyond reasonable doubt. Okay, you can extract the definition of beyond reasonable doubt from Lord Danning's judgment, Miller against Minister of Pensions, and you can refer to the case of Hu Lin Kon here. Okay, Hu Lin Kon against Wong Wei Wong. Okay, you can find the answer from here. Just a 2 marks question. And question E, Atul may wish to negotiate a settlement with Minggu, and if the settlement is reached, whether the complaint will be automatically dropped. Okay. Atu is unsure whether any other person, including bar counsel, may be substituted in place of complainant to pursue the complaint. Okay. Usually, if let's say there is a disciplinary action, it's just like normal trial. The complainant will start their case by providing all the evidence to the DC, paper, documentary evidence, and subsequently there will be session of examination in chief, cross-examination, and also the re-examination of the complainant. And then subsequently, the advocate and solicitor will need to enter into defense whenever there is a charge being formed. We call it a charge, or prima facie case had been proved against the advocate and solicitor. So it's just like a small version of a trial. So in this manner, let's say the complainant is not coming. Complainant tarik balik case lah, uh, because a lot of time had been consumed on the part of him. So he withdraw, like no need to pursue, he write a letter. So how in this sort of manner, you must refer to the act, just don't refer to one case, the Chong Yi Sen, and then finish that way. For you to get a better marks and for you to do a better answer, the primary sources that you must refer to will be first the statute. The statute reflecting the law in Malaysia. Okay, that one is the intention of Parliament. Parliament got the mandate from people to make law. So this is the highest, most authority, statute. Second, you refer to case law. This is how the approach. So where you can get this answer from the primary sources would be, you must refer to section 8 and section 9 of your legal profession, Disciplinary Proceedings Rules 2017, whereby it provides you how to do how to deal with the case whereby the complaints were being withdrawn, as well as the intervention, the stepping in by bar counsel whenever there is withdrawal of complaints. So this is how you frame your answer during examination. Okay. So I already put it later. I will send with the groups stuff to the groups. You can refer to it. Okay. So I will put my answer in such a way. Even if Mingu agrees to withdraw the complaint, the bar counsel can intervene. Okay, so this is following your section 9 of the rules on its own motion to continue pursuing it independently to address any potential misconduct. The bar counsel or another interested party can be substituted in place of Mingu to ensure a thorough investigation and adjudication of the complaint. The DC and BC will prioritize public interest and the integrity of the legal profession over private settlements, because lawyers deal with a lot of laws issue, and also money issue. If you take, for example, often than not, the complainant will suffer loss. If everything can just settle P, we call settled P or the under table settlement, okay, then there is no need for bar counsel to have this sort of disciplinary hearing at all. So public interest comes first, over private settlement. No doubt, at the end of the day, the bar counsel intended for the complainant to get some restitution of his loss. The lawyers were asked to pay whatever the amount that he run away from the complainants. That one, no doubt. But at the same time, the public interest will come in also. Okay. So therefore, while Atu can negotiate a settlement, the complaint will not be automatically dropped. And the counsel, the bar counsel can still pursue the complaint to maintain professional standards and public trust. So this one is pursuant to case of Chong Ik Sen against Majlis Peguam Negara. Okay, Chong Ik Sen, I have not met him in person, but I have heard a lot of seniors say that he was a very, very good lawyer. It's just that due to some medical illness that he or his family members suffered, he had just used the client's money. But eventually, this young fellow got struck off the roll, even though the complaint was being withdrawn. So you can draw some analogy from this particular case here. Okay. And question 4. Bong was admitted as an advocate and solicitor of High Court of Malaya 1983. He subsequently left for New Zealand to further his studies and was admitted to practice in New Zealand. Okay, see, New Zealand. He was subsequently found guilty of dishonesty and was struck off the rolls in New Zealand. Bong left for Penang and was pressured by his wife to recommence his practice. Bong, on the other hand, was so mortified by his conduct and wants to apply for his name to be removed from the rolls. Okay, so Bong is a man of conscience. That means he's quite he's quite remorseful. Okay, so we are asked to explain on the following: the recourse I highlight in red color, that the bar counsel may have against Bong. Bar counsel in your future practice, do not play a fool with them. They are extremely strict, and they are having a group of very serious lawyers that know a lot of laws. You cannot just simply buy your way out. Okay, so given Bong was guilty of dishonesty and struck off the rolls in New Zealand, the bar counsel will have several potential cause of actions against him. Okay, first thing, first thing what the bar council will do is to find a grounds to hear him. That means to say they must find a mistake before you can subject Bong to any disciplinary action. The person must be doing some sort of misconduct. So where you can find this misconduct is that in your section 94 subrule 3 and subrule 1 here. That is disbar, struck off, suspend, or censured in any other country would deem to be constitute as a misconduct. So striking off in New Zealand is automatically a misconduct. Okay, very important, eh? So after that, Bar Council on its own initiative can file a formal complaint. So usually who will file? The Secretary of Bar Council will make a statutory declaration and pay 200 ringgit to lodge a complaint in ASDB. Second thing they will do, and very fast they will do, is that they will apply under originating summon to High Court of Malaya to suspend Bong from practice until further order, because all this disciplinary action will take maybe 1 year, 2 years to complete. Meanwhile, they won't let you practice one. So Bar Council can actually do an ex parte application to suspend the advocate and solicitor from practice until further notice. This is how strict they are lah. So this is provided under section 88A subrule 1 subrule B of your Legal Profession Act. Okay, very important. And I think this is B. The Chief Justice can actually order so. Okay. Subsequently, then Bong will be subjected to DC. 3 person that I've told you. Okay. DC will conduct all the inquiries, and then subsequently they will submit a report to DB. Okay. So DB will have meeting to decide whether the Bong is liable to punishment or not. So among the penalties that DB can impose is striking off the rope. This is under your section 94, subrule 2, A and B said that suspension, but not more than 5 years lah. Okay. Fine, okay, up to 50,000 ringgit. That one is fine. Reprimand or censure, okay, that is warning. Okay. So final order will be given by DB after considering the DC report, but they can also vary or decide on its own. Okay, this is like that. But in conclusion, let's say a person, an advocate and solicitor, was caught for dishonesty and gross misconduct struck off by the register of what we call advocate and solicitor in other country, the likelihood decision is that ASDB will strike off Wong's name from the roll because the severity and gravity of the offense is very high. They will have zero tolerance towards you. So you must also uh, know what happens in real life practice. Put conclusion like that will make your answer to be more outstanding as compared to others. And you can find, again, you can draw analogy from the case of Chan Chou Wang against Malaysian Bar. And this the advocate and solicitor in this particular case law was actually struck off the roll from Singapore Bar. Okay, you can draw similar analogy from this case. And Question Roman 2, whether an advocate and solicitor may apply to have his name removed from the rolls, and if so, the procedure for such application, 5 marks. Okay, two, it is a compound question, can or cannot. First part of the answer is yes, he can do so. Okay, and this is subjected to, again, you must uh how to say, read the LPA two times now before your examination. Otherwise, you never heard of this sort of question before. Susah then. Okay, this is pursuant to your section 105 of LPA, whereby subrule 1 said that any advocate and solicitor subject to section 105 and any rules made in that behalf apply to the court to have his name removed. Okay, so how do we do? Is by originating motion plus affidavit. Okay, and subsequently, the bar counsel can order the applicant to advertise, okay. Why this one is important? Because they want to avoid those time lah. Avoid the register was not there, but then the person fraudulently or misrepresent to the client that actually he or she is a lawyer, but in fact he already being removed from the role. So last time is important for advertisement to happen. Okay, and the application, the originating motion is done in a open court setting. Okay, but not all the time, this sort of order is allowed. If let's say there is a so-called pending disciplinary action, this rule can be abused by the advocate and solicitor to evade their responsibility. Because you see, struck off from the role as compared to voluntarily removed from the role, there's a distinction, isn't it? Struck off from the roles, meaning that you lose face lah because you are guilty of some sort of misconduct. Whereby voluntary removal of the rules, next time you can say to your friends, say that, oh, you see, actually I was not struck off. I apply to the court for my name to be removed. Okay, on because of my health or personal reason. So for the court to order this sort of removal, the person must not subject to any pending disciplinary action. Okay, and the conduct of the applicant this is to balance the interest. And judge can make the decision such as striking off the rules, adjournment, etc. Okay, so this is the answer. And question B, are we graduated with a Bachelor of Laws from the National University of Malaysia in 2000? He then entered service with the Royal Malaysian Police and has been a prosecuting officer in the lower courts and subsequently served in the legal unit of many branches of the force. He's eager to commence pupillage and had approached his old friend George, who was formerly a magistrate at Teluk Datuk for 5 years, had practiced in Glang Selangor for 6 years, and is now practiced in Labuan for the past 2 years to be his pupil master. Okay, this question quite easy, must do lah. Advised are we on the following? One, whether there is any provision which allows for a shortening of his pupillage, and if yes, state the grounds. Okay, again, answer the question nicely. Yes, under Legal Profession Act, there are provisions that allow for shortening of or exemption of period of pupillage. So specifically, you must refer to section 13, subrule 3 and subrule 4. Okay, then you check with Awi's background. What happened to him? Okay, the following points are quite relevant lah. Number one is experience as prosecuting officer and also service in legal unit. Okay, so therefore, RV may apply for a shortening of his privilege based on one, special circumstances. This is provided under your section 13, sub-rule 3, sub-rule A. He can argue that I have a lot of experience in legal fields. So this will justify for the shortening of the pupillage period. And second thing, you must look at the judicial and legal service definition, because section 13 sub-rule 3 sub-rule 4 provide that if let's say a person served in judicial and legal services for more than 1 year, then he or she is entitled to seek for exemption, isn't it? So where the judicial and legal service interpretation can come from is from a case Badan Peguam Malaysia against Kerajaan Malaysia. In this case, this is not about the petition of admission for a lawyer, but then it talk about the appointment of one judicial commissioner, the JC, the judge, Okay, so in this case, they discuss about the judicial and legal provision. Judicial and legal service. Okay. A member, this one is very important. A member of the judicial and legal service can only mean a person who is employed as and works as a member of the judicial and legal service. You cannot simply submit that, oh, because he's a prosecuting officer and he's a legal unit of the Royal Malaysian Police, then he's automatically is a judicial and legal service. The law does not actually work that way. You have to define, because section 13 sub-rule 4 of LPA said that a qualified person who has served in the judicial and legal service for at least 1 year shall be exempted from serving any period of pupillage. Okay, and he must get certificate from Attorney General. So this is how you should read the law nicely. So drawing from the interpretation provided in Padang Peguam Malaysia against Kerajaan Malaysia, so Awi's practical legal experience in Royal Malaysian Police can be argued to be fallen under the scope of what we call judicial and legal service. Okay, provided he got a certificate from AG, then he can seek for exemption, okay, from doing pupillage. Okay, can follow so far. And second question is whether George has the prerequisite qualification to be a pupil master. So under section 13 sub-rule 1, okay, this one also quite easy lah, I think. Okay, a pupil master must be in active practice in Malaysia for a total period of not less than 7 years. Okay, so famous case here is Majlis Peguam Malaysia against Sunil Singh Gill. Okay, whereby the Court of Appeal clarify what does it mean. Again, this is a question of law that you must elaborate. What does it mean by active practice? Okay, so in this case, you must analyze Josh lah. I mean, Awi's friend qualification. So former magistrate is not counted. Practice in Klang Selangor for 6 years can be counted. Labuan practice for 2 years can be counted. Okay, so this is how you calculate. Okay, total active practice means 6 years plus 2 years, Labuan, based on case of Sunil Singh Gill. Because Singh Gill specifically is a case that talk about Labuan is a part of Malaysia under the meaning of section 13 sub-rule 1. Okay, because they said active practice in Malaysia. So Labuan, a part of Malaysia. Mm. So conclusion, based on the interpretation provided in Majlis Peguam against Sunil Singh Gill, George made the requisite qualification to be a pupil master. He has been in active practice in Malaysia for 8 years, including his time in Labuan, which is considered part of Malaysia for the purpose of fulfilling the requirement under Section 13 Sub-Rule 1 LPA. So therefore, Awi can proceed to have George as his pupil master. Okay, complete answer. So, in a very brief summary, for you to answer ethic and advocacy, don't simply draw some answer that is based on your personal opinion. This is a law examination. Anything you write, please substantiate it with your primary sources. Like I told you, in sequence, you must use statute or rules. Second, you come to case law. Okay, don't jumble up the what we call the sequence. Okay. Next, we will talk about, I hope to finish within 1.5 hours. Lah. Okay. Next, we will talk about insolvency case. Okay. Insolvency case. Abu is working as a GM in Lex Bank with an income of 45,000 per month and also entitled to yearly bonus of 120,000 per year lah. Okay. Abu had been working for 15 years and due to his excellent performance as the GM, he was given a house value 150,000. Abu also owns 2 apartments. He obtained a housing loan, okay, which amounted 450,000 from Bamboo Bank in 2018 to purchase both apartments at Sinaran Megah at Kuala Lumpur, which are worth 550,000 in total. So in 2020, what happened? COVID-19 broke out in Malaysia, and Abu took second loan from Bamboo Bank and purchased another apartment, Bukit Aman apartment, which is worth 250,000. So Abu rents both apartments in Sinaran Megah with total monthly rental of 6,500 ringgit. The 2 apartments at Sinaran Megah are charged to Bamboo Bank, and third apartment located at Bukit Aman also charged to Bamboo Bank. So 2 charges here. Abu has an extravagant lifestyle and he likes expensive cars and holidays. Due to this, Abu started defaulting on his housing loan repayments with Bamboo Bank. Abu moved out from Bukit Aman apartments in June 2020 and now stays with his girlfriend at Taman Maluri, Selangor. Abu sent a letter to Bamboo Bank on 25th June 2020, informing the bank that he will continue to pay his housing loan installment payment, but due to COVID pandemic, he requested for some time to pay the coming installment payment. Bamboo Bank agreed to give him 6 month extension. You see, okay. In January 2021, Abu defaulted on his loan and he has since resigned from his job at Lex Bank. Bamboo Bank has sought assistance from his girlfriend to find him, but she is unable to provide Bamboo Bank any information. In March 2021, Bamboo Bank received another letter. See, ada surat, okay, from Abu enclosing a check for the outstanding payments for January 2021 until March 2021. But at the same time, Abu requests for more time to repay loan from April 2021 until December 2021. And as he's waiting for his fund to come in from his new business selling latex gloves, Bamboo Bank rejects the request from Abu. Since then, the bank is unable to communicate or locate Abu again. Bamboo Bank now seeks your advice to their next course of action against Abu? Okay, number one, I think this question quite difficult in my personal opinion. If let's say, for example, you cannot answer all this, do not guess. You can actually do three line question. And most of the students told me they do they did the three land question, then they pass one. So the pitfall here is that you do four questions, and then likelihood you will fail. You must do five questions. And based on the facts provided, okay, Bamboo Bank needs to establish Abu has committed an act of bankruptcy. Okay, perbuatan bankruptcy, very important. Act of bankruptcy before proceeding with any bankruptcy action. This is the first thing that must be established. Okay, so the relevant provisions under Insolvency Act, which is relevant to the facts given, is Section 3, Subrule 1, Subrule D, and Subrule Roman 2, whereby this section refers to the act of departing from one residence or otherwise absent oneself with the intent to defeat or delay a creditor. Okay, and second relevant section is Section 3, Subrule 1, Subrule G, which refers to the act of giving notice to any of his creditors that he has suspended or is about to suspend the payment of his debt. Okay, so relate back to the fact he has moved out from the Bukit Aman apartment and uncontactable by Bamboo Bank since his last correspondence. So this actually, this sort of action can be seen or be inferred as an attempt to delay Bamboo Bank, especially when his last non-correspondence was to request extension of loan. Okay, so section 3, subrule 1, subrule D, Roman 2, fulfill. Okay, so section 3, subrule 1, subrule G, how do you argue? Okay, Abu sent a letter, isn't it, enclosing a check. Okay, and also simultaneously request for extension of time. So such request is can be categorized under the meaning of section 3, subrule G, subrule 1, subrule G of Insolvency Act. Okay, so this is your conclusion. Okay, and you must say the act of bankruptcy under this section 3 Insolvency Act is actually the precondition for Bamboo Bank to commence a bankruptcy action against Bamboo. Okay, prior to issue any bankruptcy notice to another one, you must have committed the act of bankruptcy. In this special event, you can see the Bamboo Bank did not obtain any judgment, isn't so? That's why they test you whether you have read section 3 thoroughly or not. Okay, usually normal circumstances in our practice, we will only commit person into act of bankruptcy when he default judgment. Okay, not default the loan. That means he did not pay a judgment. This is the normal circumstance. Okay, so but anyhow, pursuant to the proviso as listed above, Bamboo Bank can still proceed to file bankruptcy against Abu based on the discussed. Okay, and B, Bamboo Bank is aware that it would be advantageous for the bank to obtain a judgment against Abu before initiating bankruptcy proceedings against him. Assuming Bamboo Bank obtained judgment against Abu, Bamboo Bank now seeks your legal advice on the following. Okay. whether it is able to file a bankruptcy petition without first realizing the security. For a bankruptcy action, let's say the person is bankrupt, we have different categories of creditors. Number one, the first in line is always the secure creditor. The secure creditor means they have registered interest over certain asset. For example, a mortgage, a charge, something like that. Over the registered interest. So whenever the income or the what we call the proceed that come from the sale of that particular property, be it a land, a house, a shop, or even some sort of valuable machines, the secure creditor will get the money first. Second category, we have preferential creditor. Preferential creditor are usually for those who is protected under the law. For example, lembaga dalam hasil negeri, the EPF, the Employee Provident Fund. If you owe that people money, these people will come second after the secure creditors. They are called as preferential creditor. And the third category is the most disadvantageous one. They are unsecured creditor. They are lining up very, very behind. Okay. They have no any registered interest. Okay. And you do a background check, because you see, in this case, they give you a lot of money and also income, the rental. So you must put the analysis down. Okay, two apartments here charged to Bamboo Banks, and apartment at Bukit Aman charged to Bamboo Bank. The house is not a issue of concern here. So under Section 2 of Insolvency Act 1967, Section 2 is the interpretation clause of Insolvency Act. Bamboo Bank is a secure creditor because it holds charge over the two apartments at Sinaran Megah and one apartment at Bukit Aman. Okay, so you have to go one step. How to answer this question? The question asks, before you realize the security, that means to say, secure creditor, usually the first step is not to go and line up with other unsecured creditors, but actually to proceed with auction. That means lelong, foreclosure of the properties that charged to Bamboo Bank in the event of Abu's default. Okay, very important, They will not line up with other unsecured creditors. But anyhow, Section 5 Subrule 2 enables a secure creditor to file a bankruptcy petition without first realizing the security, provided conditions below is fulfilled. Because a bankruptcy order is a quasi-punishment order. A person that is bankrupt, they will have to surrender their passport. They cannot travel to overseas. They cannot own a bank account. They cannot be the director of a company. They cannot earn a salary from family members or work anyhow lah. They cannot work and they cannot sue for contractual breach, without sanction of Director General of Insolvency. Basically, a lot of restrictions have been imposed over bankrupt person's life. That's why it's punishment form, bankruptcy order. So the bank cannot simply fund because you already got charged, You already is a secure creditor. Why you want to make a person bankrupt rather than lelong the property first? isn't it? So you must have good reason. Number one is that the bamboo bank must state inside the affidavit that it is willing to surrender the Sinaran Megah and also the Bukit Aman apartment to the hands of Director General of Insolvency. Take over lah. And then you line up behind, as an unsecured creditor. Okay. And then second thing is that the bank must provide an estimate of security and debt balance. So the secured creditors must provide what is the value of the charge that you have? Okay, about 550,000 as the facts mentioned so. And the extent of the debts remain unpaid after deducting the value of security. Okay, you can find the case law that support your standing. Remember what I say, law come first, section 5, rule 2 first, then only case law. Okay, like that. You can actually file bankruptcy petition without realizing the security. You are allowed to do so. So this is your conclusion. Okay. Second question is that whether it is able to file a bankruptcy after it has realized security by way of foreclosure. Okay, that means auction already done, property charged to what we call to the bamboo bank already sold. Whether it is not enough, bamboo bank still very angry, can make the person bankrupt or not, Abu bankrupt or not. The answer is yes. Okay. So as a secure creditor, Bamboo Bank can foreclose the properties charged to it under Section 8, Sub-Rule 2 of Insolvency Act. So the assets, you must highlight lah, 2 apartments and also 1 apartment in Bukit Aman. The house, the 151, where it is not charged to Bamboo Bank, you cannot lelong, You can only WSS, read off, seizure, and sell. Okay, must know a little bit of law in your hand lah. Okay, so the total loan owed by Abu is not fully detailed. We do not know, but it includes an outstanding loan of 450,000 for the 2 apartments in Sinaran Megah. Okay, because uh, there's no clear picture here. Okay, so I will submit my answer as such. After realizing the security by foreclosure, that means lelong, Bamboo Bank can still proceed with bankruptcy petition for the remaining unpaid balance if the debt met bankruptcy threshold. Okay, so Bamboo Bank must first sell, okay, and then get the money and pay the outstanding loan, and then must calculate how much owe, okay, and you must fulfill the requirement. This one I think wrong. It's Section 5 of Insolvency Act. Okay, and you must lodge a proof of debt. Okay, this one also very important. You must senarai senarai itu apa? How much you owe. This is pursuant to your Section 40 and 42 and also Schedule C of your Insolvency Act. If let's say, for example, the remaining debts exceed 100,000, you start with bankruptcy notice. If it is not post, then you go with creditor petition. Okay, interested party can refer to my previous YouTube what we call the lecture about bankruptcy and winding up. I've listed down the procedure. Okay, so in case Su Kok Long against HSBC, the creditor can proceed with bankruptcy petition after realizing the security if the debts meets the statutory requirement. But however, you must also be a little bit sharp. You must identify that they have two loan, Okay, two loans. One is the first loan for the two properties, ma. Okay, the second loan is against the Bukit Aman punya property. You cannot combine judgment. You cannot combine two judgment and file. Oh, you see, after I have sell the Bukit Aman, the balance is 40,000. Abu still owe me. Now I have another the loan, the what we call Sinaram Megawan is 80,000. So in order for you to meet the statutory requirement, you combine. Like that is wrong, cannot. Bankruptcy notice cannot be founded on two judgment or order. Okay. And this is what we call Ri Chen Chong Fat Billy case, ex parte Hitachi list. Okay. So uh, you can put a conclusion. Bamboo Bank can file bankruptcy petition after realizing the security by way of foreclosure, provided it is more than 100,000. Okay. Then the next question, what should the bank do if Abu had already been made bankrupt? Okay. What is the proper recourse? Okay. First thing, they must notify DGI. Okay, very important. Inform DGI. Otherwise, because you have to be fair to other creditors. A person is made to be bankrupt because he owe other people money and defaulted. Okay, so inform DGI. Second, lodge a proof of debt. And third, very quick, because Bamboo Bank is a secure creditor, you must proceed with auction. Must proceed. Otherwise, you cannot get back your money. Okay. So applications of the proceed after sell, you have to calculate how much loan, and then subsequently, if there is any outstanding balance, you have to distribute. Okay, and you have to attend creditors meeting if the loan is not fully settled. Okay, you'll get the money first from the what we call from the foreclosure. If there's still outstanding, you have to line up already. Okay, like that. And last question of the day. Okay, thank God. Naidu's father passed away suddenly after a heart attack. He's unsure of the properties, be it real or personal, that the father may have, as his father was a very secretive person. Naidu had spoken to his father's close friend, who informed him that his father's assets are worth millions. Okay, see, millions. And he has a lot of properties as well as multiple bank accounts locally and overseas. Naidu is at pains to obtain particular of the assets and properties. He is also unsure whether his father had executed any will, although he remembers that his father made mention of a will some 10 years ago. So Naidu comes to you for an advice on the type of letter of representation that he may apply. Advice Naidu, 10 marks. So more like an open question, okay? It does not state what is required. So you open up your discussion. Okay, to provide comprehensive advice to Naidu regarding to letters of representation. So letters of representation here could be grant of probate, LA with will annex, or it's just LA. Correct or not? Okay, it will largely depends whether Naidu can find his father's will or not. The facts here, he's just saying that maybe yes, maybe no. So they ask you to discuss thoroughly what kind of scenario given. Okay, scenario number one is that there is valid will located. If he can find, okay, he can apply grant of probate or will annex. Okay, grant of probate can only be applied by Naidu if he is the executor named in the will. Take, for example, if the will said that, oh, I appoint my eldest son, Naidu, as the sole executor and also the sole beneficiary of this will, then I can be the pemohon for gram per bed. Okay, you understand? Okay. So the way is by saman permula, originating saman plus affidavit. And this is what I said about the difficult part of apa nama, the probate question, because you have to cite order, Okay. This is under your Order 71, Rule 5, Sub-Rule 1, ROC. And the affidavit must comply with the requirement as listed. Order 71, Rule 5, Sub-Rule 1, Sub-Rule 2, and Sub-Rule 6. So the registrar, the pendaftar lah, usually the case will go like that. Saman permula plus affidavit, then you have to file your senarai waris, you have to file your list of assets and also liability. Subsequently, there will be a hearing lah, some sort of hearing in front of timbalan pendaftar of the court, and then the registrar will inspect the original death certificate and also the will, original will. They will go through. Okay. So this is pursuant to your Order 71, Rule 4, Sub-Rule 1. Okay. After satisfying, the registrar will grant order for that probate. Okay. Then the executor, through lawyer, can extract the grant of probate according to the laws given. Okay. That's why I find it very difficult to answer probate question, because it is highly technical. You cannot just describe something or grant or probate other LA plus view annex, then you expect to score how many marks? 10 marks. Cannot one. Because this is a procedural paper. Okay. And second scenario, whereby there is a will, but the executor is unable or unwilling to act. Okay. So as the beneficiary or next of kin, Naidu can apply for LA plus will annex. Okay. The distinction between LA plus will annex and also LA alone is that if you have a will annex, the distribution of the assets shall be according to the will annex. If let's say you do not have a will at all, a letter of administration will signify that the distribution of asset will be subjected to Section 6 of Distribution Act. That means the children will get how many percent, the spouse will get how many percent, the parents will get how many percent based on Distribution Act. Whereby if there's a will annexed inside the LA, the will be respected by the court. And the distribution of asset, for example, can go 100% to Naidu, if it is so. Okay. Because at the end of the day, you must understand, I earn take for example, I set a will. Okay, I want to give, I don't want to give to my wife. Take for example, I hate her. I want to give to my girlfriend, take for example, so and so, Sharon, for example. Okay, I name Sharon as the sole executrix and also sole beneficiary of the will. No doubt, there's no legal relationship between me and Sharon, but because of this will, I have the right to decide what happened to my assets after my death. So this is how the distinction should be drawn. And the procedure most similar, or as plus affidavit, but the rules is the one that is different. So I don't know how to help you to memorize all that. And there will be inquiry by the registrar. And if the registrar is happy with all the requirement, then they'll grant order of LA with will annex. And subsequently, the LA plus will annex can be extracted from the system. So that is just like you get a surat kuasa, you can transfer the name in a pejabat tanah dan galian, you can go to the bank to take out the money. Okay, something like that. Okay. Second scenario is that you do not have will located. If let's say Naidu cannot locate the will, what happened next would be he must apply for letter of administration. Okay, letter of administration beforehand, a little bit difficult. because usually will list out the assets, oh, my bank account, my shares account, my uh these assets in Malaysia, in Singapore, take for example. If there's no will, you have to discover lah. You have to locate what are the assets, what are the bank accounts. You have to ask friends, lor, okay? And application wise, if let's say it is more than 2 million, assuming so lah, because millions of worth, isn't it? Naidu should apply by way of LA, by filing OS plus affidavit. Actually, all probate LA plus will and also LA action, OS plus affidavit. Okay. And the so-called procedure is different. Okay. The ruling is different. And registrar shall appoint Naidu as administrator pursuant to section 30 PAA, because recognizing he's the son, and Naidu shall sign satu sumpah pentadbiran, administrative oath, and subsequently, after the hearing and all that, if the registrar satisfied with the what we call the Naidu's application, LA shall be granted. So this is the summary lah. If there's a will, can apply grant of probate or LA plus will annex. If no will, can only go for LA after discovering the asset. Okay. And we come to the last question. You are asked to define what is caveat, what may a caveat be entered, what is the effect of caveat, etc. Okay. So caveat, as we know, some of the time when there is a multi-millionaire die, lah, for example, a will can be forged, because for a will to be valid, there are only a few criteria. Number one is that the will maker must be more than 18 years old, and then the will is being written, and then subsequent there are two what we call witness, attestation witness, uh, that are neutral, that are not the beneficiaries of the will, sign. Then the will can be upheld already, to be valid. So some of the time, if let's say um a person, a fraudulent family member of next of kin lah, made up a will, forge a will, then apply for grant of probate, you get everything the multimillionaire own, So this caveat action is actually a legal notice, to stop the grant of probate, even if there is a presence of will, something like that. Okay, this is in Form 164, Order 71, Rule 37, Subrule 3 of Rules of Court. Okay, maybe I can show you one example of what is caveat, something like this, It is going to look like this, Okay, tidak dibenarkan pemberian dimeteraikan dalam harta pusaka so and so yang mati pada so and so tanpa diketahui oleh pemohon, something like that. So that means to say, you stop the grant of representation altogether by this caveat. It's a form of notice. Okay, so a person that lodged a caveat will have a similar effect like your private caveat in the land lah. That person cannot get probate or letter of administration. Otherwise, they will transfer out all the bank accounts and also the properties into their name. You have a difficult life. Okay. So when may a caveat be entered? Again, section 33 PAA said that you can enter caveat anytime after the death of the deceased. That's why when you are advising on a family dispute, in how to say, in after a death, usually a rich man lah, after the death of his death, Okay, so the family members start making hoo-ha. First step that you should protect the family members is not to challenge or sue each other, is to go to Bahagian Surat Kuasa Mati in Kuala Lumpur High Court to check whether some other family member had taken the step to extract LA or grant of probate. That one is actually the first step. If it is so, you must quickly enter caveat to prevent them to do so. Okay, so this is second thing before representation has been granted. If representation had been granted, be it LA or grant of probate, too late. You cannot you cannot start any action. Okay, so what is the effect of caveat? The effect of the caveat is to stop all the proceeding, okay, of grant of probate or LA in respect to the deceased property. That means everything stop. Nobody will get what they want. And actually, in probate action, we have two types. First is contentious probate action. That means somebody file a writ against another, disputing the rights over the assets. Okay. Second is non-contentious probate. Okay. So this caveat actually turns a non-contentious probate into a contentious probate action, because non-contentious probate is just summon permular plus affidavit, attach the will, plus all the certificate of death and other documents, then you'll get the grant. But contentious probate, it shall be like convert this summon permular into a writ action already. You have to tender evidence, okay, to challenge validity of the will, as well as we like to challenge something like suspicious circumstances surrounding the making of the will. Okay, and what happened next is that the person that got caveated, take for example, I caveat take for example, this is my grandmother passed away. Grandmother passed away. So my uncle applied for LA. So he's the caveatee. I apply to caveat to stop his LA proceeding. I'm the caveator. Okay. So the caveatee can actually issue a warning in Form 165 and serve it on caveator and registrar. Okay. And the caveator, me lah, I have to enter appearance to show contrary interest. Okay. That means why I object, I must tell the timbalan pendaftar. And next, when does caveat cease to be effective? So this caveat has a lifespan of 6 months. Okay. And second thing, it can be voluntarily withdrawn by the person that entered the caveat. Or third, when there is a default of appearance, that means you didn't come. By right, you should come if the other party issue you a warning, but you didn't come. Okay, that means you are forfeiting your rights. So citation, what is citation? Citation is a legal notice to inform person whose interest may be affected by probate proceeding, giving them the opportunity to appear and take part in the proceedings if they wish. Okay, this is typically issued when the executors or administrator delay to apply for grant of probate or letter of LA. Okay, this is how it works. If you are the administrator or executors of the will, you must perform your function. You must go to land office, change name. You must go bank to take out the money and distribute accordingly. But what if you do want to do after you get the grant of probate? Citation enable the beneficiaries to take action against you. They will go and challenge you. Hey, why you don't want to execute? After you get this grant of probate, you get the order already. What? Why you don't want to go to the bank? Why you don't want to go to the pejabat tanah? You want to give up your status as administrator or executor or not. So these are the function of citation. Okay. And there are three types. Whether the executor accept or refuse administration. Okay. Second, whether the citation wanted to take the probate or to withdraw or renounce means I give up lah. I give up the right. I don't want to execute your will lah because so legit, so many uh the dispute and so many arguments I have to involve with family member, something like that. And to propound a will. Okay, that means to say who a person that claims to have interest under a will to formally prove a will in the court. So this is citation, and you have to again cite Order 71, Rule 42, Sub Rule 1. Okay. Whew. Here comes the end of our discussion. I'm pretty sure it's a lengthy session. Just stop the recording first. Do you all still